going through the program in custody, but it means getting through the aftercare and everything else successfully. If you do all of that, then you're still on these deferred probations. You still don't have felony convictions on your record. This is, again, the opportunity of your lifetime right now for you to make the changes and do the right thing. If you don't, and you come back in here, then you are going to end up with 2 felony convictions, and you're going to end up going to TDC for up to 10 years in one case and state jail prison for up to 2 in that case. Do you understand?
Yes, ma'am.
Let me explain something else. I am also now making it a condition of your probation that you treat the staff and the correctional officers at our jail and at Safety and wherever you are with respect, and you follow all of the rules when you're incarcerated. That means if I get another incident report before you get to state jail, before you get to Safety, it's already a violation of your probation. They're going to let me know, and you're never even going to make it to Safety. You're going to be right back in here and looking at going to prison. Do you understand?
Yes, ma'am.
So the way you're talking to them at our jail, you cannot keep doing that. You cannot keep arguing. You can't keep fighting. You can't keep saying, F that, I don't care, things like that. Okay. And you're looking at me like you're confused, that maybe you didn't do these things, but this is what I have. Every time you act up, every time you tell someone, if you're going to send me out, just do it. F that, or whatever it is, that's disrespectful.
Yes, ma'am.
All right. They're just trying to go there and do their job every day. Hopefully someday that's what you want to do. Get out of jail, go to work, and not have somebody treating you like this when you're at your job. Right?
Yes, ma'am.
All right. So, you'll sign some paperwork today for Safety, and okay, I guess just obviously by what I'm looking at, that seems, am I looking at the right thing? Dakota Chapman, the first violation is that he committed the offense of murder.
That has been abandoned.
That was not.
Yeah, definitely.
Okay,
I'm sorry.
thank
Maybe
you.
we should have started with that.
We're just going to go to Safety and
No.
okay.
That
So
was done in December.
here's let's do this. I'd like to go ahead and go through the motions, get pleas of true or not true to the remaining counts, and then obviously if you guys have an agreement, we'll look at that. But I think I want to go through and have those pleas on here.
And that came at the recommendation of his supervisor, who
Okay.
I'm sure has much more information for the court as well.
That's good. Thank you. If you want to print this section, I'll just do the first one on here. All right. Well, he waived the formal reading of the motion in each case. Mr. Chapman, in clause number 23, DCCR 1077, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of evading arrest or detention with the use of a vehicle, a 3rd-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And then in clause number 23, DCCR 1078, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation May 6th of 2024 for the offense of accident involving injury, a state jail felony, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
And so the state is going to abandon each case count 1, correct?
Correct, Judge, based on the comments of the grand jury.
So, Mr. Chapman, in each case, the motions allege you violated your probation. Count 2 in each case alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 in each case alleges that you provided a urine sample March 12th of 2025 that tested positive for cocaine. Is that true or not true? Count 4 alleges that you provided a sample September 3rd of 2025 that tested positive for methamphetamines and amphetamines. Is that true?
True.
Count 5 in each case alleges that you admitted to your probation officer to using the illegal drug ecstasy December 3rd of 2025. Is that true or not
True.
true? I'm sorry. Count 6 alleges in each case that you were at a location other than your residence at approximately 1:53 a.m. December 21st of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you failed to successfully complete the defensive driving course as ordered. Is that true or not true?
True.
Count 8 in each case alleges that you are behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true in each case to counts 2 through 8 freely and voluntarily? And did you plead true to those counts because they're actually true? So it's my understanding, Mr. Chapman, that the recommendation is that I continue your probation and order you to enter and successfully complete the special needs safety. Is that your understanding?
Yes.
Is there any reason to get any type of pre-sentence report or update?
Only at the court's discretion, Judge. The officer, Ms. Valier, has already prepared for the court the continuation and modification of that special condition if the court would like that to be signed off on today. Otherwise, I'm sure she'd be happy to do a quick update.
If it's her recommendation, we'll just go ahead and go forward.
I
So,
think that was, I'm sorry to interrupt, I think that was done prior to count 1 that we see, which obviously caught everyone's attention and just took that immediately off the table. But
Right.
since that was no build, I think that's when she finds herself back in the same position.
so Mr. Chapman, you're getting your second chance today.
Yes, ma'am.
There's not going to be a third. Okay. You need to take advantage of this. I don't know what happened. The night of December 21st of 25, obviously it was no build as far as the offense, but you were clearly somewhere you shouldn't have been doing some things you shouldn't have been doing, right?
Yes.
If you had been home during curfew, you never would have been charged with anything. There wouldn't have been any issue of whether or not you did anything, right?
Yes, ma'am.
So I want to make sure you understand if I go along with this and send you to safety, you're going to get some tools so that you can hopefully stop using drugs, do the right thing, live your life like the rest of us and not end up in prison. Do you understand all that?
Yes, ma'am.
All right. So at this time in each of your cases,
I don't know how the court would feel about an extension, Judge, based on the age.
yeah. So at least in the evading,
Okay.
I'm going to do that. I'm also we're going to talk a little about the jail incident reports as well in just a
Yes,
minute.
ma'am.
So I'm going to find in each of your cases that you entered your pleas of true to counts 2 through 8 freely and voluntarily. Find those counts true, find sufficient evidence in each of your cases to revoke your probation. But I'm going to go along with this agreement today, and I'm going to continue your probation in each of your cases. In clause number 23 DCCR 1077, I am going to extend your probation by 2 years. And I'm going to order in each of your cases that you enter and successfully complete safety. That obviously means, I think that's it as far as adding a condition, the condition. So add 2 years in the one case and the condition with regard to being successful and not being disrespectful.
Yes,
Okay.
ma'am.
All right. Good luck to you. You can go back with the bailiff. And here's that. Derek Corbin.
Judge, on this one that I previously was evaluated for competency. He is competent. I got a new offer from the state on him. I was gonna ask him, let me sit him 1 week so I can have some family to talk to him. He's a little better, but it's still some issue.
We'll reset Derek Corbin 1 week.
1 week.
Velma Gilbert.
Thelma Gilbert.
No, I didn't. I still need to, I'm gonna go through all those cases. Okay. Yeah. That's a lot. That's good.
Good morning. Are you Thelma Gilbert?
Yes, ma'am.
And Ms. Gilbert, in cause number 26, DCCR 0502 is charged with credit debit card abuse. 26, DCCR 0503, charged with burglary of a habitation. 0504, charged with credit debit card abuse. 0505, charged with credit or debit card abuse. 0506, charged with credit or debit card abuse. 0507, charged with fraudulent use or possession of identifying information. And 0508, charged with theft of property. And what is the announcement?
Judge, I've gone through most of these cases. I've talked to Ms. Gilbert about it. Also about her other situation yesterday it's going on. She is currently on parole. So there's a parole hold on dealing with her as well. I just need to finish up going through a little of some of that stuff. I haven't been on it that long,
No,
but and considering that the offer will be something substantial as far as
Sure.
the resolution, I just need a little time with it.
All right, so I'm gonna just do a normal reset. That'll give Mr. Lewis time to get through everything and all of the discovery and all of your cases, go through that with you, and then we'll get an announcement at the next court date. All right, you can go back with the bailiff. So these are two different people, Tan Van Pham and Van Tam Pham, and you've got both of them?
It's the same person. It's the same person, and that's the issue that I'm having.
Okay,
So we did have the same.
Previously, there was a Thai Van Pham with similar cases.
okay.
He has pled and been sentenced and on his way.
So all of these, 1, 2, 3,
Seven.
4, 5, 6, 7 cases are the same person?
Same person.
Okay, Tan Van Pham, please. Pham.
And for a while, we had them both on the same dockets, which
And I was previously appointed on the.
Some of
first.
them will just have the name flip, Van
Right.
Pan instead of Tan
Right.
Pan. Okay. Good morning.
Good morning, ma'am.
You are Tan Van Pham,
Yes, ma'am.
and Mr. Pham has 7 cases, all charged with theft of property with previous convictions. And what is the announcement?
Judge, on this situation, he has several cases that he's charged with. We had another defendant that very similar situation, same name, that was on the same docket at one point. And it's questionable if some of these or the other person, to be honest with you, they're both actually from the same area or put off. And so I'm trying to go through all the surveillance just to make sure who's who.
Okay.
So I would at least like.
And it looks like we've got 3 different kind of indictment
Right.
timeframes on these. Some not. So Mr. Pham, I'm going to reset your case one more time to give Mr. Lewis time to go through all of that. He'll be out there to visit with you, and we'll get an announcement at the next court date.
Yes.
All right, you can go back with the
She
bailiff.
said she want to give me a network there.
Yeah, we're getting deported.
You don't know why they hold me here. I didn't do nothing.
Well, Mr. Lewis will talk to you about that, okay?
Okay, go back.
What about April Smith?
That's the one that was reset from last week, Judge, with the
Sentencing on
Safety.
April Smith?
right.
What was that for?
Her husband talked to her about the safety.
We had asked the court to consider safety based on her priors. You didn't know if you wanted to do that last week. You allowed her husband to go out and talk with her about how much she really needs safety for her children, but of course, we ultimately left it to your decision.
So what about the 2 new cases?
Well, our offer, Judge, just in
April Smith coming?
in hindsight was that we would kind of wait to see what the court's position was with respect to safety. Those were actually on the grand jury cart at last docket. I have since been assigned them. And so if we need to plead to one or both of them, we can do that and expedite her to safety if we go that direction. Otherwise, the offer was to first take the 2-year stay jail on the probation case and to plead to at least one of those offenses so that there's the priors in her history.
Right. I think when the pleas were done, those were abandoned at that time because they haven't been presented yet.
I don't even know that we had them in the office. They have since been indicted last week, and I now have them and can prove them up by next week if the court would like.
Well, what's your client's position with regard to that offer of safety?
Oh, she definitely wants to do the safe peach.
Then I want pleas of everything today, if I'm going to do that. She's got to take responsibility for those new cases if y'all want to get the paperwork done for whatever agreement you've reached on those. But I mean, I don't think dismissals is appropriate.
No,
In
we,
the other ones.
and that wasn't the plan
Okay.
necessarily. When we didn't have them,
Yeah.
it was, let's not hold her up for safety,
Sure.
but now that we have a cause number to plead to. with.
Yeah, we need to get them all taken care of today. All right?
We'll take care of that.
Yes, sir. I'll hold it.
Thanks.
And then you've got Jordan Thomas.
Well, Judge Thompson.
Jordan Thomas.
Gordon Thompson.
Good morning.
Jordan.
Good morning. Been waiting all morning.
I know.
And Judge, this is when I was retained on right during that transition when Ms. French took over those cases. So we've had a little time to talk, but not much.
Good morning. Are you Jordan Thomas?
Yes, ma'am.
And this is cause numbers 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child, and 24 DCCR 2178 charged with aggravated assault with a deadly weapon. And Mr. Lewis, what is the announcement?
Judge, this is one I've been previously retained on, or recently.
Yeah, okay, I see that.
Retained on. I got on this case. I've talked to Ms. French a little bit about it. She's reviewed it over the weekend actually and gave me an offer this morning
Okay,
in regards to where you are. I do have discovery. So I just need to go sit down with Mr.
Sure.
Thomas. So
okay. We'll just do a normal reset, give you plenty of time to go over everything with Mr. Thomas, and we'll get an announcement at the next court date.
Yes, ma'am.
All right, Mr. Thomas, we'll see you at the next court date.
All right.
And I'm holding April Smith, okay. And then Ms. Perazo.
You still sign the rejections, no?
Oh, I feel like we've already done. I don't know if she needs to do all those, but I see that she's doing them. Don't get that set.
After you're on one.
Do you? Say, Mr. Rojas, what was I holding for you? Jimmy Couch?
Jimmy Couch.
If we can reset him, Mr. Couch wants to file a bond reduction.
Okay, I'll reset Mr. Couch.
Jimmy Couch, we don't need.
Judge Mark,
Reset.
complainant is here today. She has spoken with myself and Mr. Rojas, both, and we will be objecting to that bond reduction.
Okay, so we'll take care of it then at that time. Obviously, if there's evidence that would help me bring whatever witnesses you need. What about Willie Pugh?
Willie Pugh, Judge, if we can reset that, I'm going to file a motion to suppress on that, but that may be dispositive.
All right, we'll reset Mr. Pugh as well.
And Judge, that could probably be just one day, maybe on a non-jury week after a regular docket.
Okay, perfect. Thank you.
Hey, just
Thank you, Mr. Rojas. So Mr. Gertz had to go to, oh, hi. Good morning. I was like, where is he?
If I was
You're standing.
any closer to you, we'd probably be in trouble, right?
That would, right. On Giovanni Coleman.
Yeah, Judge, may I have a few minutes on that?
Yeah, I'll hold it.
Sure.
And then they're working on. Yeah. Silent Hill. I know, I've already gone, so I love his stuff.
So, Ms. Palazzo was ill,
But that was on
Who?
initial rate.
and Giovanni.
Oh, well, let's just,
Yeah.
it's okay. Just get the order and I'll sign it and let's go to the court plan. Mm-hmm. Yes, ma'am.
I can.
Is Ms. Delage? Looks like we have Mr. Rojas here. Good morning.
Good morning.
And I was in a hurry, thinking I was late.
Well, I said he's next to the laundry out of it, but he doesn't have.
See, Mr. Rojas, you've got Jamon Adams.
Devon Adams.
Good morning. Are you Jamon Adams?
Yes, ma'am.
This is 26 DCCR 0744. Looks like Mr. Adams is charged with aggravated assault with a deadly weapon, and Mr. Rojas has filed a motion asking that I reduce the bond currently set at 150,000. Is that correct?
That's correct, Your Honor.
Mr. Adams, the best you can, raise your right hand, please, sir. Do you swear?
Oh, yeah.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Jamon, how old are you?
21,
Where are you originally from?
Houston.
Okay, but when this incident happened, you were living here in town with your dad?
Yes, sir.
And your dad's the victim is complaining witness in this case, right?
Yes, sir.
Okay. How long have you been in jail?
Since April 8th.
And the only other person other than your father that can realistically help you with this is your mom, right?
Yes, sir.
Okay. And your mom, you've talked with her and you've talked to she's unable to make a bond of $150,000.
No, sir.
Okay. Do you own any property that you could sell, a house, a car, a land? Do you have a bank account in your name?
Yes, sir.
Do you know approximately how much money is in that account?
Probably zero, maybe in the negative.
Okay. This is, again, you're 17 years old. This is the very first time you've been arrested, right?
Yes, sir.
Okay. Your mom's gonna help you out with the bond if we can get it lowered, and I think maybe an aunt. He said maybe there's an aunt out there that can help her.
Yes.
Okay. Are you married?
No, sir.
Do you have any kids?
No, sir.
Okay, so it's just you.
Just me.
So if you're able to make a bond, like I said, before this, you were living with your dad. What's your plan? If the judge will let you want to go live with your mom in Austin?
Yes, so I will go to Austin. I already have a job lined up for myself. She's holding it down for me right now. She's also working to get her own apartment so that I can go move in with her, then I can start working and continue back on my plan to get back in school.
Okay. And you say get back in school, but was that in high school?
No,
Okay. Where were you going to college at?
probably get relief from university. It's in San Antonio.
Okay. And once you're able to get this all behind you, that's your plan to get back into college.
Yes.
All right. That's witness, Jeff.
Just so we're clear, you're 21 years old, right? Not 17. I think that was a misstatement.
Yes.
Okay.
21, yes.
Apologize. Did I say that?
I think you said 17.
Okay.
I know it's an error.
Right.
I have another question, George.
Okay. Any other witnesses?
No, Judge.
Mr. Nichols, what's the state's position?
Judge, he's accused of breaking into his own home after he'd been kicked out, and when his father tried to push him out the window that he broke in through, he grabbed a knife and stabbed him. I think 150 is appropriate in this situation, Judge.
And for the record, I am taking judicial notice of the court's file. It includes the probable cause affidavit. If you'll give me just a second, let me So you said you would be going to Austin if you make bond, no matter what that is, and living with your mom. Is that correct?
Yes.
But that she would be getting her own place. Where does she live now?
I believe it's one of those homes where she's pays for that space.
Okay.
I believe the money she's paying there, she can also pay for an apartment. So that's what she's doing while working both jobs.
And what's the job that you would have?
I would have the IHOP job. That's her second job. That's the job that I will be going to.
When's the last time you were in school?
I believe in May of 2024. That's when I left college. Then keep up the $40,000.
Speak up.
I said I cannot keep up the $40,000 on my own for tuition.
Any history that you can?
Minor juvenile, I think an arrest and a non-suit out of Harris County for murdering when he was a juvenile, but nothing else, right?
All right, so what I'm going to do, Mr. Adams, I'm going to grant the motion. I'm going to reduce your bond for $100,000. Condition of that bond, if you make it, is going to be that you obviously have absolutely no contact, no communication with David Keys. You will be ordered to wear a GPS monitoring device. You will be allowed to live in Austin with your mom. You would have to get that address before you go to your attorney or to your bondsman. And also, obviously, not be anywhere near the residence at 1970 Ave Street. Do you understand?
Yes, ma'am.
No contact and no communication means none. That not sending messages obviously means in person, but it also means sending any type of messages yourself or through anybody else or anything like that. You understand?
Yes, ma'am. I have no intentions.
And we'll reset it for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you, Judge.
See Cody Arnold. Mr. Rojas.
I don't have the attachment that I'll be to this afternoon.
Okay, thank you. Good morning. Are you Cody Arnold?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Arnold, in cause number 26, DCCR 0488, you're charged with the third-degree felony offense of harassment of a public servant from January 30th January 30th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arnold is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk to Mr. Rojas. All right, good luck to you, sir. You go back with the bailiff.
Yeah, go.
As this hearing comes to a close, one thing becomes clear. The court was willing to offer a second chance, but not without strict conditions and a serious warning. The judge made it clear that probation is an opportunity, not a guarantee, and every choice moving forward will determine whether the defendant rebuilds his life or faces years behind bars. Cases like this show how the justice system balances accountability with rehabilitation, giving people a path forward while demanding responsibility in return. The real question is, when someone is given a second chance like this, should the court continue offering opportunities, or is there a point where enough is enough?